However, that avowed resumption by the suspended Senator Natasha Akpoti-Uduaghan did not hold. The Senate then went on a one-week recess in honor of Nigeria's former president, late President Muhammadu Buhari. Now, upon this, deliberations are different sides and arguments to the stories. But the most recent is an appeal by the President of the Senate, Senator Godswill Akpabio, appealing the judgment as delivered by Justice Binta Nyako, reinstating suspended Senator Natasha Akpoti-Uduaghan. He has also urged the court to invoke Section 15 of the Court of Appeal Act to resolve his preliminary objection and dismiss the entire case. Well, joining us on the program this morning is also a learned man, Barrister Mfon Udeme. Good morning to you, Barrister, and welcome to the program.
Thank you very much. It's a great pleasure to be here.
Now let's get into this. It's now supposedly a case of the National Assembly versus the court. Okay. How do we adjudge from the outside looking in provisions for the law? Is this a conflict of law in the House or in the National Assembly versus law as it were in the courtrooms?
Well, it's standard practice. We are running a constitutional democracy, a democracy that is founded on the dictates of law, and Section 6 of the Constitution of the Federal Republic of Nigeria empowers the judiciary to be the arbiter in where there are issues between persons or between the institution of government. So it's absolutely in order. There is no conflict at all. And it is the duty of the court, where there are grievances by parties, to also use the instrumentality of the Constitution to decide on such matters. So there is certainly no conflict. There is certainly no issues, except that, of course, in doing the work, in doing the job, each of the arm of government is expected to respect the principles of the separation of powers. So there are certain areas where the judiciary may not be expected to dabble into, just as well as the Senate may not also take actions where the judiciary also has the power to do so. So we are seeing the constitutional democracy in place, at play, and we are very hopeful that at the end of the day, justice shall surely be served. Justice for the Senate as an institution, and of course to the parties as officers of the arms of government.
Now let's speak about the subject of the judgment as delivered by His Lordship Justice Binta Nyako. The Senate had replied that they were waiting to see the certified true copies of the judgment before allowing for her resumption, but there were also conditions given in terms of the publish of apologies in dailies by Senator Natasha following defamations of the Senate President and the National Assembly as an institution. Do you see a gap in this communication? Why did she avow that she would resume despite the fact that some of the conditions on ground were not met?
Thank you very much. The point must be made, at least at this point, that we are, or personally, I'm here to address the issues, the facts as are stated in the judgment. I must make it very clear to our viewers that we are not referring to issues on maybe the internet or social media platforms and all of that. We're dwelling strictly on the matters as it were in court, and of course in respect of the applications that were filed. I was in court from the inception of the matter until the day the judgment was delivered. As a matter of fact, I sat through the judgment when it was delivered, and I've also had the opportunity to go through the certified true copy of the judgment. So I'm stating the fact as it is. There was never a time that the applicant, that is the plaintiff or claimant, as you may call the person, that is Senator Natasha Akpoti, there was never any time that there was a prayer by her seeking to be recalled. This is the point that must be made very clear. And courts usually will not award reliefs that weren't contained in your originating processes. So her case before the court was simply about the fact that she had certain privileges that, according to her, were breached, and that indeed she ought not to have been invited by the Committee on Ethics of the Senate, and that indeed the issue of her being directed to resume a particular seat wasn't within the powers of the Senate. These were the issues that were canvassed basically in her case before the court. And of course, the court took, gave a very well delivered judgment to the effect that she was wrong, that the Senate had the power according to the rules. You have committed yourself to be a member of the Senate, and you must
abide by her rules.
Abide by the rule.
Now, Barrister, let me make for good read here and also carry our viewers along. I'd like to refer to certain orders in the CTC as made available to us here.
All right.
Now, order number 2, I'll read any quotes.
Okay.
That having found that the plaintiff acted in breach of this court's subsisting order, the plaintiff must take the responsibility for her action and remedy same. Thus, an order is hereby made for the plaintiff to pay a fine of the sum of 5 million naira to the federal government's treasury and to publish a public apology to the court in 2 national dailies and on her Facebook page within 7 days of today to purge herself of contempt. That was delivered on the 4th of July. To your best of knowledge, has the plaintiff complied with this order number 2 as delivered in the judgment?
Now, it's very unfortunate that the orders of a competent court has been disobeyed once again, because...
So you're saying to your best of knowledge 7 days has elapsed and none of those have been done?
Of course, that hasn't been done. And that again speaks to the character of the plaintiff. There was a contempt in the first instance of her breaching the rules of the Senate. And the Senate, as a law-abiding institution governed by rules, referred her to the Committee on Ethics to investigate, to find out why will you act against the standard practice. Now, she ran to court. She arrived court and committed another contempt. And the court again has ruled that, look, you must apply decorum. You must be civil. You must obey the rules. And yet again, she has disobeyed the judgment of court. And we're told again that there is an appeal. But I must tell you, to the best of my knowledge, that the procedure for getting an appeal to, to be entered, we're yet to even receive the appeal. So maybe we should use this opportunity to advise that law is not practiced in social media. Yes, social media is very good. You can use it to pass information. But you see, you must have a foundation before you can build on it.
But one of the conditions of order 2 is that she also issues an apology on her Facebook page.
Now, that is mandatory at this point because it's an order of court. She is bound to obey that order because it is founded upon a finding of court that indeed she committed contempt. In fact, as we speak, the law looks at her as a criminal, someone who has committed a wrong. That is according to the court judgment. So we would have expected that within 7 days, an apology would have been issued, and of course, a publication as the court directed would have been complied with. But unfortunately, that has been done, or that hasn't been done. And even the fine that was imposed on her, we were yet to see if she's complied with that. Rather, the other thing that is very disturbing is the posturing that she will be resuming, in the Senate, even when there was no such clear order to that effect.
I don't know if this is clear enough, but orders 10, 11, and 12 on the CTC, I refer to the the others again, and I'll read it again for the benefit of our viewers. Order 10 on the judgment says, and I quote, that to suspend a member for a period of 6 months equals a suspension of 180 days, and that this is the same number of days a member is expected to sit in the House representing his people. That I find this excessive and overreaching, noting that it prevents a member from complying with Section 63 of the 1999 Constitution. Now to Order 11. Order 11 reads that I am of the opinion that the Senate has the power to review the provisions of the Senate's rule and can even amend Section 14(2) of the Legislative House's Powers and Privileges Act, both for being excessive and overreaching. And Order 12 says that the Senate has the power to, and I believe, should recall the plaintiff and allow her to resume representing the people who sent her there to represent them. Issued at Abuja under the seal of this Honorable Court and the hand of the presiding judge, this date, 4th date of July 2025, signed by Registrar Kanu Ngozi B. So now looking at Order 10 and 11, 12, I'm a layman. You're the learned person here. What I deduce is that it also did make a case for her recall. Do you think this is what informed her
absolutely not. Absolutely not. You see, you must understand, like you've stated, there is the ratio of a matter and there is the obiter. An advisory, well and good.
So this is an advisory in the government?
Certainly there is no clear order on the Senate to recall. Rather, you would have observed that what you're stating is that the court upheld the power
of the Senate
to even amend its rule to accommodate issues like that. And aid an opinion, like you stated, that our opinion is that perhaps the duration of suspension may be lengthy and may deprive the
her constituents
from being represented. Well and good. You must know that the Senate, as a law-abiding institution, has properly appealed against those obiter, even when they were not the meat of the issue, the crux of what was brought. As a matter of fact, like I stated, there was no way in the suit by the plaintiff where she had canvassed
and prayed for a recall
that yes, that she was on suspension. And mind you, maybe we should state this background. This suit was filed on the 3rd day of that was March. There was no suspension as at the date that the suit was filed. So there was no way the court would have ordered for suspension. And one of the objections of the Senate was to the fact that the suit was premature. The cause of action has not arisen when the matter was filed in court. So at what point will you have had a prayer in order for you to have an answer? So what you've just read is, with due respect to His Lordship Bintan Yako, is looking at the whole gamut of the issue and making remarks that may guide the parties. I must also note that in court, the learned judge was very, very explicit about the fact that the issue of separation of power, that must be respected. And of course, again, that the representation of a constituency should be founded on a member or a representative who upholds the rules of where she finds herself. So even when indeed the constituency may be deprived, that they have a responsibility, a duty to always ensure they do not elect persons who will go into, for instance, an assembly or a legislative house and not obey the rules. So the Honorable Justice Bintan Yako was of the opinion that indeed the Senator Natasha should apologize because she flouted the rules of where she belonged. In fact, she clearly pointed out that you had no right even to speak when you did not obey the rules that you should be on, speaking from your seat. You see, and sometimes people make attempts to trivialize these basics, basic decorum and standards. When I arrived at your studio, I could not sit anywhere.
I appointed
you invited me and you told me, oh, please sit here. Supposing I disobey your, standard, you will certainly not be having this interview.
Very correctly. Now let's go back to the order so that we speak in reference to this, because it's very good to have real-time interpretation of some of the orders as captured on the CTT. Okay. Now, speaking to the position of the powers that the Senate has, if those who follow the CCT and have it available on social media platforms would also do well to refer to Orders 7 and 8. 7 says, and I read, that I also find that the Senate rule is superior to the Legislative House, Powers and Privileges yes. Act by virtue of Section 20 thereof.
Yes.
Order 8 now reads that Order 6 of the Senate rules gives the power to allocate and relocate seats to senators to the Senate President without conditions. End of quote. Now, it goes to back and buttress the points you made earlier. But when we look at the fact that millions of Nigerians following this issue tend to look away from the provisions of rules, either as enshrined in our constitution or as encapsulated in the rules that guides the National Assembly in deliberations during plenary, does this worry you in terms of our followership versus the position of leadership?
Certainly, I must admit that I get very worried about, even the younger generation, worried about even the students. As a teacher, as a law teacher myself, I wonder if some of the training we give to our students, they actually take them serious. A clear case that is in point here is about one who is expected to be a lawyer going public to say, I am resuming in the Senate, when indeed even the certified true copy of the judgment, the procedure that is expected for the enforcement of the judgment hasn't been followed. So you wonder, is this person really a lawyer? Does she understand the rules? So we need to really conscientize our people, both the young and even the adults, to understand that anywhere in the world, for those who are Christians, even when you get to heaven, there are basic standards you must follow. And we need not allow the pensions to run to social media, to the public, to discredit people, to be part of our culture. Because I notice, rather than people stay on the issues, they rather enjoy them. I'm told it's content creation, people are making money. But unfortunately, the Senate is a very serious institution. It is not where you go to create content. So maybe we should really take a very serious action to ensure that this sort of issue that we've witnessed in this particular 10th Senate doesn't repeat itself. And I trust the leadership of His Excellency Senator Akpoti-Uduaghan. He's a very experienced legislator. He's had a broad-based experience even in the executive arm of government. So I am very, very sure that the Senate knows to ensure that matters of this nature don't even occur again. And I must also commend the Senate as an institution, and of course the Senate President, because from when the issue was debated about the report by the Ethics Committee, I, for the first time, sat through the entire session. I was in the plenary to observe what were the findings and of course the rules or the ruling of the Senate. I will not forget that even when all the senators were unanimous in saying that the Senator Natasha must face the discipline of the Senate, the Senate President, as a father, was very magnanimous to appeal to his colleagues that any time that she apologizes, that he will rule that he should or she should be forgiven. But you see, unfortunately, till today,
she hasn't apologized.
The whole country is still waiting for her to do her part.
Now you've brought him in. Let's talk about him. He's a party in the case as well. We've talked about the plaintiff. He, the Senate President, Senator Akpoti-Uduaghan, has filed an 11 grounds of appeal.
Yes.
In which he has faulted the decision of the Federal High Court in the objection of his earlier appeal.
Yes.
Can you tell us about this 11 grounds and why he chose to file this objection faulting the decision of the court?
No, it's a basic principles of law that you cannot, for instance, assume jurisdiction in a matter for which the cause of action has not arisen. You cannot. What are you adjudicating upon? You are talking about a suspension, as at the date of your filing the suit, there was no issue of suspension. That is part of the grounds of the appeal. And the Senate is very, as an institution, very clear on the fact that there must be respect for the separation of powers.
Because I also saw that he's insisting that this is an internal issue,
yes, certainly,
and therefore should not be in the purview of the court.
Certainly. So
is this
that is the point. That is the point. Yes, there is the powers of the Senate to regulate its activities
without the interference of a federal high court.
Not at all. Not at all. If there are issues perhaps that are within the powers of the court to decide, they are free to do so. But if it is about the discipline, the coordination of the activities of the Senate, the Constitution put that squarely on the Senate as an institution to regulate these activities. And of course, even the judiciary also has its own powers. You have the National Judicial Council, you have all of the arms, departments of the judiciary that also discipline its members. This is so that we can have a society that is, governed by rules. Otherwise, you will have where every whim and caprice of everybody will suffice in dealing with issues in the country or in the society. So we cannot allow any human being, anybody, any individual to create an impression that you cannot follow the rules, and that's what the Senate is stating in its appeal.
Now, again, as a journalist, I'm watching this from the outside.
Okay.
Both of the parties involved have legal teams.
Okay.
I don't know if you're part of the legal team of the Senate President.
Well, I'm a lawyer basically, and I have interest in the matter, and of course, I consult for the President of the Senate.
Okay, now for the legal team of the plaintiff here in question, do you think that they haven't advised her enough, knowing that they should understand these provisions of the law in regards to her position on this matter and her posturing?
Well, I read a postulation by Niccolo Machiavelli, and it has guided me even about some claims that I encounter. And it stated that one who is not wise cannot be well advised. What that means is that you may give all the advice that you may have as a legal practitioner. Sometimes you may have a client who may not take the advice. So I certainly don't have any issue with the legal team. I would rather expect that the parties in the matter should be wise enough to take counsel. When they are properly counseled, they should be able, to take that advice. So I am of the thinking that perhaps the party may be going overboard, maybe merely dwelling on sentiments and not allowing the guide of the law to regulate her activity. So it's not about the legal team. The law is very clear, and I will expect that going forward, that there should be an enforcement of the judgment of the court. And of course, like you've noted, there is an appeal. We are expecting that the Court of Appeal, will look at these issues that have been presented and make the proper decision. And that's why our system has allowed a graduation of, the legal wrong. So if you are not satisfied at the lower wrong, you can step up, and of course, you have it to the Supreme Court. All of these are, standards set to ensure that we have a society that is properly governed by rules and not by sentiments.
Well, pending the outcome of that appeal, yes, I'm hoping that we can reconvene and continue this conversation from where we left off. Yeah. But I must thank you, Barrister Mfon Udeme, for taking out time to lend your thoughts and help interpret some of the orders as captured in that 12 orders we've seen in the CTC of the judgment as delivered by His Lordship Justice Binta Nyako. We appreciate you for making out time to be on the program.
Thank you. I appreciate it. It's a pleasure anytime. All right.